Last thing I want to touch on is just there are a few things you should keep in mind in terms of maintenance. Trademark protection only applies to the extent that you actually continue to use your trademark. If you stop using your trademark, you will lose those trademark rights. In addition, you have to file certain trademark maintenance paperwork on a regular basis. So we started to talk about that briefly. You'll get your registration certificate. It'll have a registration date on it. That's the date that's going to trigger your renewal paperwork. So between the 5th and 6th anniversary of that registration date, you file what we call a declaration of use. And you also have the option, although everyone does, go ahead and file a declaration of incontestability, which is just, I've been using my trademark for 5 years now. Nobody's raised an objection. Nobody sued me over this. I can now claim it as incontestable, and it'll be too late for anybody to come along and try to challenge me on it later. And then at the 10th anniversary, you're going to do that declaration of use again, right? I'm still using my trademark, and a renewal. The other thing I want you to keep in mind is that trademark registrations are public records. This means that you are going to get a lot of fraudulent notices from organizations that make themselves look like they're associated with the government, but that are not actually from the government. This is especially common right before it's time for you to do your renewal paperwork. And they will, they'll come from Alexandria, Virginia, right outside of DC. They'll look very official. And all it is they're going to tell you, hey, it's time for you to renew, pay us this filing fee. We'll get this taken care of. You've got to pay this fee, right? And it's a scam, and they disappear with your money. It's something that the trademark office has been trying to crack down on, and they're just frankly doing a terrible job at. They're public records, so it's easy to get this information and trick people.
Yeah.
The trademark office also technically doesn't police your trademark for you, okay? The only thing that they're doing is preventing new applications for confusingly similar trademarks. That has nothing to do with everybody that's running around starting businesses and selling products or services that never actually tries to register the trademark. And you can lose your trademark rights if you just allow other people to infringe upon your trademark. We talked earlier about marks becoming generic, right? Like, you let people, you call it aspirin all the time. Eventually it just becomes a common word. You lose that trademark right. So same thing. You don't want to just let everybody use your trademark on the internet just because that's such a common thing these days. And plus, as a practical matter, you don't want your customers to go, oh, it's the same thing. I'll just go buy it from over here, right? You want them to follow your brand to you and not to your competitors. Don't get too cocky and just start sending out random cease and desist letters without investigating first. A lot of times people get their registration certificate and they're like, great, I'm going to fire off cease and desist letters to everybody. Don't do that. Trademark rights, yes, registration is important, but your rights are actually based on who was using it first, right? And so they might have been using it. They might have some common law rights. They might be entitled to keep using it in their little geographic area. We need to figure that out before you just try to send out a nasty cease and desist letter. And then if your business is going to be involved with maybe joint ventures or licensing deals where you do let other people use your trademarks for different reasons, you can engage in what we call naked licensing, which just means that in your contracts, there needs to be some standard, right? Here are the standards for if you're going to partner up with my business and use my trademark, right? You've got to, stick to this quality of product or service, right? You've got to abide by these rules, right? These types of things. If you just let everybody use it all willy-nilly, again, the law will eventually take your trademark away from you. Okay. So with that, I will open it up. If there's any other questions, I definitely want to hit those. And then I'll also, just very briefly, again, I am not the come hire me, right? There are lots of great attorneys out there. I tell everybody go with somebody that you know, like, and trust. But if you are interested in working with me or having a further conversation about trademarks and how to protect your brand, I generally work with, entrepreneurs, founders, dreamers, the innovators, right? The passion people. So let's talk about what you're passionate about. What's the best way it is to protect that passion? And you've got our scheduling link right there. So you can always just schedule something on our website.
Thank you. So my question is, if I was a nurse, and this is interesting because this actually happened to me a couple years ago. I trademarked Everyday Divinity, and there was nothing ever happened with it. It was no big deal. And I believe it was maybe 2 years ago, a company out of California contacted me who they had filed for their trademark of the same name, Everyday Divinity, and they were going to be using that in the capacity of a mental health thing. And so it was interesting because I never in a million years would have thought anybody would be contacting me to discuss this. And I reached out to you, was like, be okay, they're using it for mental health. And you were like, yeah, but what if they come across the nation and they have all these companies everywhere, and then it basically just liquidates your company, Everyday Divinity? Or what if something bad happens with them and then everybody thinks that you're associated with them? So it does happen. As small fry as I am, it does happen. There are names out there. And unfortunately, that company had built their website, all their marketing tools, they had everything already into it. And, it's kind of like, you should have looked that up prior to filing. And I was already long gone with my trademark, and they just never looked into it. And so that does happen. So I don't want nurses to think, oh, I'm just a small fry, nobody's ever going to pick my name or anything. And as weird of a name as Everyday Divinity is, it has gotten used in other countries by nail technicians, and which I don't chase after, but it's been used by a church, and there's been a couple of things that it's been used by, and I don't go after that kind of stuff, but it is interesting because that did happen. A company used the name and they were very big as far as their pockets went. And I thought, you know what, because of course they were throwing their money around and telling me, and everything. And I thought, if you got the money, then you got the money to change it out. You shouldn't have done it. You should have hired the appropriate legal processes and looked into it. And so they didn't do that. But my question was, when you were talking, okay, as a nurse starting out, so honestly, they could file for that supplementary register first to kind of get the ball going before doing the official trademarking then. So that would be, or would you just say, what is the fee considered? Because if you're going to do the trademark, would it just be better just to go forward the trademark, or just, you know what I mean? Is it a waste of effort, money, and time?
I've never known anybody to say, let's intentionally start with the supplementary register. It's usually, let's try it and see if we can get it through here. And then if we can't, the trademark office will move it down to the supplementary register, right?
Yeah.
Like, yeah, we don't need to start there. We don't need to give that away. I mean, same thing with the disclaimers, right? Like, if I were doing, red delicious apples, and of course that couldn't actually work, but then they came along, they're like, well, you've got to disclaim the, apple, because everybody's got the right to use apple, right? Oftentimes I won't put that in the initial application. I'll make them tell us we've got to change it and say, okay, yeah, fine, we'll disclaim apples. Right.
Okay. My other question, when I filed for the trademark, one of the ways that they verified the name of the company was through a website. So is that something that is necessary for trademarking? Do you need to have a live website? Because that's how they found my name, Everyday Divinity, was one big long word versus 2 words. And so I just wonder if it is something that you should, is it easier if you wait to get that website live and launched? And then you can use that as your date of usage, or does it matter?
Technically, it doesn't matter. I mean, you don't have to have a website. The website issue comes up a lot, especially with service-based businesses, because remember, we have to submit that specimen. And so it's usually like, hey, here's how we're advertising our services, right? And we'll say, here's a screenshot of the website that very clearly shows trademark and a call to action, like schedule a meeting or, purchase a book or whatever it might be, right? And so that's where the website tends to come into play, is usually in that context. So we'll do it for something like that.
Okay, that makes sense then. I think those are my 2 questions.
Yeah, you brought up a good point with what happened with Everyday Divinity and a competitor or somebody else coming along and asking for permission to use it, because it touches on, I think, that juxtaposition between, if I'm starting my business, I'm putting everything I've got into marketing, right? Nobody wants to call the attorney, right? That's not fun. You want to talk to the graphic designer, you want to talk to the website designer, you want to get your brochure, your business cards, whatever the case might be. And the trick is, you can't put so much into the marketing and so much time and money into that, and then you find out you've got to start over because of the trademark.
Yeah,
Right.
I know. I was like sick over saying no. I mean, but then when you honestly, now that I look back and like can evaluate the process of it, I can see how it was, she reached out to me and kind of became like friendly. And I'm like, oh, they sent the woman to befriend me, to kind of be like, come on, we can work in the same space. It's okay. And I just was like, what if something happens? And with you, when you're working with the senior demographic, you really don't have the time and the capacity to go and do damage control. And they don't understand all of this stuff. And so it's really hard to go. After I thought about it and I thought, if something does happen and they go huge and they're like a Walgreens and they're all over the place, and then there's bad PR around that, the seniors are going to just assume that you're affiliated with them. That's just the easy way. They don't recognize that there's all these different entities and such. And so I just was like, you know what, I don't want to have to go and do damage control with a bunch of seniors in Ohio, explaining that I'm not affiliated with that. And so I just was like, yeah, no, I'm good. And so I don't regret that decision at all. But when it was happening, I was like, oh, it'll be okay. You were like,
And it's also,
I
it's
don't think
such a
so.
slippery slope, right? I mean,
Yes.
the more of that you allow, it shouldn't be the case, but the more of that you allow, the more of that the trademark office allows, the more likely it is that the next application that comes along, everyday div, right? They're like, yeah, sure. I mean, there's a couple of these already. What's the big deal to let one more through?
Yeah.
And then it really starts to get diluted, right? And so that's what we're trying to avoid. That's what we're trying to protect. But of course, if you're on the other side of that, you have to ask, right? I mean, I've yet to have anybody say yes, but you have to ask, because if you had said yes and entered into an agreement, then they would have used that to try to get their trademark through the process. So it's a lot, right? I mean, this stuff is complicated. There are a lot of things that can go wrong, a lot of issues that can pop up, but it's really important if your business is built on, this is my brand.
Yeah. That's it. Well, thank you so much for doing this. And we will have your contact information is listed at the end of the webinar. And I will also put it in the webinar notes so people can reach out to you, because you can trademark, since it's a federal thing, you can do trademarking for anyone nationally, correct?
Yeah, since that's the federal issue, that, yeah, we can work on that for pretty much anybody in the country.
Well, perfect. Well, I will recommend you because you've been very honest and very helpful to me when I first started and such. So it was really good, because I was like, I don't have a lot of money to do all this big stuff, but you were really, very patient, and I recommend you to a lot of people actually, because I'm like, she helps me, so she'll help you too. So it was so awesome.
I greatly appreciate that.
Thank you so much. Oh, you have to stop it.